Mental illness and substance use disorder affect millions of Americans and thousands of West Virginians. It's hard for family and friends to watch as a loved one suffers. Mental illness or substance use disorder, or a combination of the two, may make a person likely to cause serious harm to themselves or someone else. If that is the case, crisis intervention services are available from local mental health facilities. There is a list of West Virginia community mental health centers on the West Virginia System of Care website, which is wvsystemofcare.org. Unfortunately, people who are in the middle of a mental health or substance use disorder crisis might not realize it. They may not acknowledge how their illness affects the ways they think and behave, or how it affects their relationships with others. They may also refuse to seek help. If someone is a danger to themselves or others and refuses help, there is something a relative or friend can do. In West Virginia, any adult may seek to have such a person involuntarily committed to a treatment facility. This video explains the involuntary commitment process. The application for involuntary commitment is available on the West Virginia Judiciary website, which is courtswv.gov. It is under the heading Mental Hygiene and Guardians. There are separate applications for adults, juveniles, and people who are incarcerated in a prison or jail. This video explains the process for involuntary commitment of adults. The person seeking to involuntarily commit someone else is called the petitioner. The person who is the subject of the petition is called the respondent. The petitioner should fill out the form and be sure to answer every question thoroughly. It is better to provide too much information rather than not enough. If you do not know the answer to a question, simply state that you do not know. The petitioner must explain in detail the respondent's mental illness and/or substance use disorder, how the respondent has refused voluntary treatment, and how the respondent is likely to cause serious harm to themselves or someone else. During business hours, applications should be filed at the office of the circuit clerk in the county where the respondent lives or can be found. After business hours, petitioners should contact the local mental health center, the county sheriff's office, local hospital, or in some regions, 911 emergency services. These agencies are familiar with the commitment process and will have information on how to file involuntary commitment petitions after hours in emergency circumstances. Once an application is filed, a judicial officer will review the petition and determine whether to enter an order to have the respondent evaluated. Circuit judges have jurisdiction over involuntary commitment cases. Judges may appoint attorneys as mental hygiene commissioners or designate magistrates to preside in these cases. Mental hygiene commissioners and designated magistrates are judicial officers and have authority to enter probable cause orders. Circuit judges must enter final commitment orders, although the hearings may be held by mental hygiene commissioners. The judicial officer will review the application and decide if it meets all legal criteria for approval. If the application does meet all the legal criteria for approval, the judicial officer will enter an order to have the respondent detained by the county sheriff or one of his deputies. The deputy will take the respondent into custody and then take him to be evaluated by a licensed evaluator. The respondent will remain in the sheriff's custody for the duration of these proceedings. If the evaluator determines that the respondent has a mental illness or substance use disorder, and the respondent is likely to seriously harm or kill himself or others due to that mental illness or substance use disorder, then a hearing is scheduled. Some of these terms have specific legal definitions that must be met. In West Virginia law, a mentally ill person is defined as a person whose ability to function intellectually, emotionally, or physically is significantly impaired. Substance use disorder is defined as a pattern of alcohol or drug use that significantly diminishes a person's ability to work, go to school, care for children or a household, or operate a motor vehicle. The term likely to cause serious harm to themselves or others means the respondent has tried to, or actually has, physically harmed another person or themselves, or has placed another person in reasonable fear of physical harm. For example, this can include incidents when a respondent may not mean to harm anyone, but may cause harm accidentally while reacting to hallucinations. Attempting suicide is one way a person can harm themselves, but it is not the only way. Likely to cause serious harm also can mean a person is not doing something, like not eating, not taking their medication, or not seeking medical help. Not taking care of his own need for shelter and self-protection can also be a version of self-harm. If a person is not doing something to the point they might be seriously injured or die, that fits the legal definition of likely to cause serious harm to themselves. The potential injury can be physical or mental. If the evaluator does not find that the respondent has a mental illness or substance use disorder, or finds that he does have a mental illness or substance use disorder, but he is not likely to seriously harm or kill himself or others due to that mental illness or substance use disorder, then the case is dismissed without a hearing. If there is a finding that leads to a hearing, the Mental Hygiene Commissioner will appoint an attorney to represent the respondent during all stages of the commitment process. This attorney's fees will be paid by the state, not the respondent. This attorney should interview both the petitioner and the respondent and review the evaluation that has been completed. The petitioner and the respondent must get a notice of the hearing. The respondent often finds out from their attorney. The initial hearing of the petition should be held within 24 hours of the time the petition is filed. The respondent's attorney can ask for a brief delay, up to 48 hours, to prepare. If there is a delay, the respondent will remain in law enforcement custody for the duration of the delay. The hearing may also be rescheduled if the respondent needs medical care. The respondent must be present at the hearing and has the right to present evidence, to examine testimony offered, and to remain silent. The respondent's attorney can cross-examine witnesses. This hearing is called a probable cause hearing. Probable cause means there is reasonable basis to believe something is more likely than not. The presiding judicial officer must protect the rights and interests of the respondent as well as the interests of the state. The judicial officer must determine whether there is probable cause that the respondent has a mental illness or a substance use disorder, whether the respondent has refused help, and whether the respondent is likely to cause serious harm to themselves or someone else as a result of the mental illness or substance use disorder. Involuntary commitment hearings are relatively informal and may take place in a courthouse, a hospital, a mental health facility, or another appropriate location. Sometimes the judicial officer or medical professionals appear by video. Normally, there is no court reporter present and no recording is made of the probable cause hearing. The prosecuting attorney is not required to be there, but may represent the petitioner if the prosecutor thinks it is in the best interest of the public. The petitioner can request the prosecuting attorney be notified of the proceeding. The Mental Hygiene Commissioner or magistrate who presides at these hearings must consider information from judicial, medical, psychological, and other evaluators. In addition to information about the respondent's current behavior, the judicial officer must consider psychosocial, medical, hospitalization, and psychiatric records, including information about the circumstances of any previous commitments. If the Mental Hygiene Commissioner orders that the respondent should be involuntarily committed to a treatment facility, the commitment cannot exceed 20 days, unless there is another hearing about whether there should be a more lengthy commitment. A sheriff's deputy will transport the respondent to a treatment facility. Once the respondent is committed to a treatment facility, he or she must have a medical evaluation within 3 days. A physician must determine whether the respondent is mentally ill or addicted and likely to be a danger to themselves or others if released. If this evaluation is not completed in 5 days, the respondent must be discharged immediately. If the evaluation determines that the behavior which led to the involuntary hospitalization was caused by a physical condition or disorder rather than mental illness or addiction, the respondent is immediately released. The judicial officer who ordered the involuntary hospitalization dismisses the case, and the respondent's name is removed from the mental hygiene registry, and all of their rights, including their right to possess weapons, are restored. If the doctor conducting the evaluation determines the respondent requires long-term treatment, the chief medical officer must file an application for final commitment, and another hearing must be held. The application for final commitment must state that the doctor believes that because of the symptoms of mental illness and/or substance use disorder, the respondent is likely to cause serious harm to himself or others. The application must state recent overt acts of the respondent to support the belief. Once a petition for final commitment is filed, the judicial officer has 15 days to hold a hearing on the petition. If a hearing is not held within 15 days, the respondent must be released. The circuit clerk must give at least 8 days' notice of the hearing to the respondent, the applicant, the spouse, the adult next of kin, the mental health authorities, the circuit court, counsel for the respondent, and the prosecuting attorney. All proceedings, including the final commitment hearing, must be completed within 35 days of the date of the original commitment. If not, the respondent must be immediately released. After the final commitment petition is filed, but before the hearing, the respondent may be examined by an independent physician or psychologist appointed by the judicial officer. That doctor will report the findings to the judicial officer. If the respondent is indigent, the county where the respondent lives pays for the independent evaluation. If the respondent refuses to submit the examination, the judicial officer shall order the person to do so. If the examination report does not find that the person has a mental illness and/or substance use disorder and is likely to cause harm to himself or others, the final commitment proceeding is dismissed. At the final hearing, the prosecutor will be present, and the judicial officer hears all relevant material evidence from all interested parties, including representatives from the community mental health facility and the physician or psychologist who completed the certification of the respondent. The respondent cannot be compelled to testify. All final hearings are either recorded or a court reporter attends. At a final hearing, the judicial officer must make a ruling, called a finding, that there is clear and convincing evidence that the respondent is mentally ill and/or has a substance use disorder, and that as a result is likely to cause harm to themselves or others if allowed to remain at liberty. The judicial officer must also determine that there is no less restrictive alternative than commitment. The person who is seeking final commitment has the burden to prove there is no less restrictive alternative. The judicial officer's ruling is called Findings of Fact and Conclusions of Law. The ruling is sent to a circuit judge. The circuit judge enters the final order. That order must be received by the mental health facility within 10 days of the final hearing. At this stage, as at the initial hearing, the parties could come to an agreement calling for voluntary treatment. If that is the case, the respondent may be released. If the respondent does not follow through on the voluntary agreement, the petitioner can ask for another hearing. The purpose of that hearing is to determine whether the respondent has complied with the voluntary treatment agreement and whether they remain a serious danger to themselves or others. If the judicial officer determines the respondent has not complied, the respondent can be involuntarily committed. At the final hearing, the judicial officer may commit the respondent to a mental health facility for 90 days. If the chief medical officer determines that the respondent requires commitment and treatment longer than 90 days, the respondent shall remain there until the chief medical officer determines that the respondent's clinical presentation no longer requires further commitment and treatment, up to 2 years. The Chief Medical Officer shall provide notice, including how the respondent continues to meet commitment criteria and ongoing treatment, to the court, the prosecuting attorney, the respondent, and the respondent's guardian and/or attorney. Any of the individuals who are notified may request additional information to justify ongoing commitment and treatment, and the court may hold any hearings it considers appropriate. If the respondent goes to a mental health facility for an indeterminate time, the physician may determine that additional hospitalization is necessary beyond the 2 years. In that case, the respondent or the respondent's lawyer may request a hearing. Conversely, the chief medical officer of a mental health facility is required by law to release any involuntary patient who, in that medical officer's opinion, has recovered or whose hospitalization is no longer necessary. At the final hearing, if the judicial officer determines that the respondent does not have a mental illness or substance use disorder, then the proceeding is dismissed. Also, if the judicial officer determines the respondent does have a mental illness and/or substance use disorder, but is not likely to cause serious harm to themselves or others, then the judicial officer must dismiss the case. The judicial officer also has another alternative. Instead of hospitalization, the judicial officer may order the respondent to be put in the custody of some responsible person who will agree to take care of the respondent. This most often happens when the respondent is not a resident of West Virginia, but has been previously hospitalized in West Virginia. In those cases, the respondent can be returned to their home state. Respondents can appeal any of these commitment orders. All of the proceedings, records, and reports of involuntary commitment proceedings are strictly confidential and are not released without a court order or the individual's consent. People who are involuntarily committed are prohibited from possessing and receiving firearms and ammunition, in some cases for their entire lives. They must immediately surrender any firearms they own or that are in their possession. Any commitment for treatment of mental illness is reported to both federal and state database registries used for firearm purchases and permits or licenses to carry concealed weapons. The process we have just talked about is for adults who are mentally ill or addicted but not incarcerated. There are different processes for incarcerated adults and juveniles. If someone you know is mentally ill or has a substance use disorder and is a danger to themselves or others, you can intervene and help them. You can call the closest community mental health center for voluntary treatment options, or you can file a petition for involuntary commitment. It is up to you to take action.